one of the outcomes from the big report was that a Supreme Court was established in New South Wales. That was in 1824. After the establishment of the court, we start to see Aboriginal people being engaged in legal actions. Some of those, a small amount, were civil, so they could have been around debtor type issues. But the vast majority of these actions were in fact criminal. So as the colonists moved out across New South Wales, an interesting phenomenon occurs where you start to see people enter into sometimes quite friendly relationships, but over time these tend to disintegrate. As more and more colonists push into an area, it becomes obvious they are becoming a permanent fixture. They are less tolerant of Indigenous peoples. The Indigenous peoples realise that they've come to stay. Tensions arise, and then some of those that are known to colonists become involved in acts that we would think of today as frontier warfare, but at the time they're characterised as being a burglary, a murder or some other such act. Those who were known to the colonists tended then, under certain conditions, to be arrested. They would be taken into custody. Sometimes they would be clamped into leg irons. They would then be conveyed often to Sydney for trial, and then later to Melbourne when the Port Phillip district was established. So they could be made to march for many, many, many miles behind someone that could have been on horseback. They could be conveyed by river and by sea on boats. One such fellow in the 1820s, simply known to us as Jackie, had been arrested after an altercation where a group of armed men had ridden up and surprised an Aboriginal encampment by a river at night. He had thrown a spear, allegedly, that had struck a colonist who later died. Jackie was brought down on the King William River steamer. He was left naked on the deck of the steamer, chained. The ankle chain bit right through to the bone. This was later revealed in court. He was kept in jail in Sydney. He was tried here. He was later sent down to Hobart, where he had to be admitted to hospital straight away. And he died within weeks, presumably from, in part, the infection that would have set in around the wound, as well as potentially removal from country and the harm that caused him, obviously change of diet and a range of other factors. Aboriginal people being brought before the law courts was contentious. Some colonists really objected to it. They thought it made a mockery of British law. But there were steps put in place. These steps were in part possibly helpful, but also very much justificatory. So Aboriginal people were put on trial so long as an interpreter or translator could be found who at least claimed to be able to understand the language of the person concerned, because by this time in the 1820s, colonists realised there were many Aboriginal languages. Initially they'd thought there to be just one. An interpreter would be found. Sometimes they were someone like an umbrella seller from George Street. We don't know how well he actually knew the language he claimed to be able to speak. A very well-known figure in the colonial courthouse was the missionary Reverend Lancelot Threlkeld from Port Macquarie. He was sworn in as an interpreter for Aboriginal men. He, though, relied very heavily on his Indigenous informant Biraban, who actually did the interpreting. But because Biraban wasn't taken to be fully Christian, he couldn't swear an oath and couldn't be sworn in as an interpreter. At the same time, Aboriginal people themselves couldn't swear an oath. At the time anyway, evidence wasn't generally heard from those who stood accused. One feature I found very fascinating in reading about trials of Aboriginal people was that when they were given a choice of a military or a civil jury, they often just simply said, no soldier. It really makes you wonder what was going on out at the frontier that made Aboriginal people so concerned about not wanting anything to do with these soldiers.